Welcome to another presentation from the Filmmakers Legal Clinic at Cardozo Law School. The Filmmakers Legal Clinic provides free legal services to filmmakers and video journalists who are seeking to move the social justice needle. We also provide educational programs and trainings for our industry partners. If you are interested in becoming a client or partnering with us, please contact us. Today's presentation focuses on fair use, a subset of copyright. After a brief introduction, I will provide overviews of copyright and fair use before diving into the fair use factors, and end with some tips and best practices for using copyrighted materials in your film. As the filmmaker, you or your production company should be sure that you own the right to use all of the copyrighted material included in your film. When a work is created, there is a copyright attached to it, and there are a few ways to be sure that you have the authority to use this copyright. Either you own it yourself, you license it from its owner, or it falls under the fair use defense to copyright infringement. The work created by an employee of a production company is by default owned by the production company. The work created by an independent contractor must be specifically commissioned, along with other requirements, to be owned by the production company. As a general best practice, you should include a work-for-hire provision in the contracts which you provide to any other parties working on the film, and a clarifying copyright ownership provision in license agreements, option agreements, and the like. You can refer to our contracts module for more in-depth information on these essential contractual mechanisms for owning your film's copyright. However, what happens when you want to use pre-existing third-party materials like videos, sounds, and recordings, images, articles, etc. in your film that you do not own? There are several options. In some cases, you will need to license them from the owner to avoid copyright infringement. Alternatively, if you're familiar with copyright law and the risks associated with infringement liability, you can perform a risk analysis to determine if a license is truly necessary in your specific circumstances. In other cases, you can use these materials because they fall under the copyright fair use doctrine, which we will cover in depth in this module. We'll begin with a copyright law overview. Copyright law is originally codified in Article 1, Section 8 of the United States Constitution, where the founders set forth the notion that authors, inventors, and other creators should have the right to secure for a limited time the exclusive rights to their works. To carry out the founders' intentions, Congress enacted the Federal Copyright Act, which offers copyright protection to original works of authorship fixed in a tangible medium of expression. If a work meets the statutory requirements for copyright protection, the copyright owner possesses certain exclusive rights for a limited duration of time, including the right to reproduce, distribute, publicly perform, and prepare derivative works based upon the copyrighted work. In addition to possessing a right to exclusively use their work, the copyright owner possesses a remedy in court when a third party infringes upon those rights. If your film were to include depictions of Mickey Mouse, for example, without permission, Disney, the copyright owner, would have a remedy in court to sue you or your film for infringement upon its exclusive reproduction rights. For any party seeking to use copyright-protected works, seeking a license to use such materials is typically the recommended practice to avoid potential litigation. However, as we will discuss, there are alternatives and defenses available to infringement claims, including the fair use doctrine. The fair use doctrine seeks to promote free expression by allowing for the unlicensed use of copyright-protected works in limited circumstances. Fair use helps accomplish the policy underlying the intellectual property clause by encouraging new creation where an author's control of copyright may otherwise stifle such innovation. A fair use of copyrighted work is not an infringement of that copyright. The Copyright Act details certain presumptive categories of fair use, including comment, criticism, news reporting, scholarship, teaching, and research. However, fair use is an equitable rule of reason, meaning that your use does not need to fit into one of these categories in order to be deemed fair. Most importantly, the Copyright Act provides a four-factor balancing test that courts apply when determining whether a use is fair. These factors are not dispositive on their own, and courts apply the test to circumstances on a case-by-case basis. The four factors are: first, the purpose and character of the use; second, the nature of the copyrighted work; Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth, the effect of the use upon the potential market for or value of the copyrighted work. Next, we will discuss the fair use factors. The first factor concerns the purpose and character of use. This requires us to focus on two questions. First, whether the use is transformative, and second, whether the new work is commercial. To determine whether a work is transformative, courts look to see if the new work adds something that alters the first work by giving it new expression or meaning. A finding that the work is transformative weighs heavily in favor of fair use. Conversely, a finding that the work is commercial in nature cuts against deeming the use fair. In the leading case on this matter, Campbell v. Acuff Rose, the court found that the purpose of a parody of the song Pretty Woman by Two Live Crew was transformative because it criticized the original song by Roy Orbison, as well as commented on the juxtaposition of the nature of the original song versus the culture of pursuing a woman described in Two Live Crew's song. The question of whether your work is commercial or not is a bit more straightforward. Do you seek to profit from the work? Is it commercial in nature, or is it for nonprofit or educational purposes? Documentary films can often claim to be non-commercial. Another famed case on the subject, Harper and Row versus Nation Enterprises, explains that the crux of the commercial-non-commercial distinction is not whether the sole motive of the use is monetary gain, but whether the user stands to profit from exploitation of the copyrighted material without paying the customary price. However, the Supreme Court has said that where a work is highly transformative, less weight may be afforded to other factors, like commercialism, that could weigh against a finding of fair use. Accordingly, a use is more likely to be found fair where it is deemed transformative. A quick note on applying the fair use doctrine to music specifically. Musical works are difficult to transform, and the heart of the work is inherently subjective. For this reason, it is considerably more difficult to prove fair use for music than for other types of art and copyrightable works. The second factor concerns the nature of the original copyrighted work. A court will ask whether the original work is expressive or more factual in nature. Where the original work is predominantly factual, the law favors dissemination of such work. Thus, the copying of works that were originally intended to relay factual information are more likely to be considered fair uses. For this reason, the use of materials such as news reports and articles will more often fall under fair use. The second inquiry for this factor is whether the original work is published or unpublished. Unpublished works enjoy a stronger level of protection than published works. This is because it is at the core of copyright protection for an author to determine when, where, and in what form their work is published. The third factor concerns the amount and substantiality of the portion that the user took from the original work in comparison to the original work as a whole. This involves a quantitative and qualitative analysis into how the original work was used in the new work and how much of the work appears in the new work. Quantity must be examined relative to the length and/or size of the original work. In the case Bill Graham Archives versus Kindersley, the defendant reproduced the entirety of a Grateful Dead poster, this factor weighing heavily against fair use. However, if the new work uses only a small portion of the original work, the new work may qualify as a de minimis use, which is deemed to be fair. In Gottlieb versus Paramount Pictures, a branded pinball machine in the background of a movie scene was found to be de minimis and thus not a violation of the pinball brand owner's copyright because its branding was hardly recognizable. Substantiality is a qualitative measure that looks to whether the new work has reproduced the essence or the heart of the work. A short frame of a motion picture, for example, may contain the most creative element of the work, and therefore, using or reproducing it would not be favored under fair use. This analysis also considers whether the use was reasonable and/or necessary in light of the new work's purpose. The fourth factor concerns the effect of the use upon the potential market for or value of the copyrighted work. This factor looks not only to whether the new work actually harmed the market for the original work, but also whether it could harm the potential market for the original work. To make such a determination, the court's main inquiry is whether the new work usurps or substitutes the market for the original work. Citing Harper and Row once again, to negate fair use, one need only show that if the challenged use should become widespread, it would adversely affect the potential market for the copyrighted work. Where a work is determined to be transformative under Factor 1, a court is more likely to find that it does not substitute the market for the original work here under Factor 4. If you are using third-party materials in your film, you should typically seek to properly license them from the owners to avoid liability for copyright infringement. However, you may also determine that the risk of copyright infringement does not outweigh the price of licensing the materials in your specific circumstances. Alternatively, many filmmakers rely on the fair use doctrine for their use of unlicensed materials that would more than likely weigh in their favor using the four-part test that I have just explained. The Filmmakers Legal Clinic can help our clients make this determination. See here for an overview of the fair use factors that you can reference back to. Here are some helpful tips to consider throughout the filmmaking process. A full and proper fair use analysis should be conducted upon the completion of a final cut of your film. Until then, you should track all third-party material used in your film in an organized and comprehensive manner, including the source, timestamp, length used, permission, and any other information you have. Considering the fair use factors, there are some general tips to consider when electing to use unlicensed third-party materials in your film that might make such uses more likely to be considered fair. First, materials containing factual information, like news reports and articles, will more likely fall under fair use. Second, to make the third-party material that you are using as unidentifiable as possible by, for example, making sure it is distant in the background, featured for only a few seconds at a time, or is otherwise reduced. Third, try to transform the third-party material to the furthest extent possible while still getting the point you need it to make across. This can include adding media, a filter, or sounds over a clip, image, or recording, drastically changing the circumstances in which it is used, or otherwise considerably altering the material. Last, try to use as little of the material as possible. Quantitatively, this means using the shortest or smallest portion possible of a video, image, or recording. Qualitatively, this means that you should avoid using the pivotal scene from a movie or the one component of a famous painting that makes it famous. Thank you for watching. You can send us an email at filmmakerslegalclinic@yu.edu or apply as a client on our website at filmmakerslegalclinic.org. The Filmmakers Legal Clinic is housed at Cardozo School of Law's Center for Visual Advocacy and sits at the intersection of film, law, and social justice. The clinic provides free transactional, intellectual property, and First Amendment legal services to independent filmmakers whose work encourages and accelerates social change.